questions for the discussion. And I would also like to thank Martin Shainin because he provided to me very valuable feedback on the draft version of the paper, which I'm going to present to you today. So the reason why I decided to write the paper is because I saw a real challenge, which is that our existing legal frameworks or the formulation of the prohibition of discrimination as we have it at the moment doesn't address all the challenges which arise from the context of artificial intelligence technology. And I am not alone in this opinion. We have Rafael Xenidis, who is we're very lucky to have her here. I know she writes about this issue as well. We also have experts advising the Council of Europe who highlighted the deficiency of existing frameworks both at domestic and international law levels. And this is not just individuals who are closely studying these systems from a literature standpoint of view. We see a recurrent number of cases where the use of artificial intelligence technology to produce decisions about people's entitlements to resources such as jobs, for example, or healthcare, lead to situations where individuals who have historically experienced disempowerment are disproportionately and negatively affected. For example, in the United Kingdom, we have persons with disabilities arguing that they're disproportionately being flagged as a risk in terms of fraudulently claiming benefits. We had a big scandal in the Netherlands where the government used artificial intelligence to flag, again, benefit fraud, and we saw ethnic and religious minorities being disproportionately targeted. And the consequences are very real, because in the Netherlands, some families became divorced because of the stress. Some of the families declared bankruptcy, so we see very real consequences against the backdrop of our laws being drafted with human interactions and organizations in mind. And so this is a problem I really much wanted to tackle, but from my perspective, it was really important to develop a solution which would work within the existing legal framework. Now, I argue that it is actually using CEDAW and CRPD as a case study, that it is possible to embed new legal tests into the existing treaties. So as you know, CEDAW is a treaty which prohibits gender discrimination, and CRPD is a treaty which prohibits disability discrimination. Now, I thought, well, if I am to develop a solution, then I need another general test, which is based on existing scholarship and legal theory. And then I need to derive additional rights from this general test, which would be specific to the artificial intelligence technology. So the idea here is that I propose a test which is very much embedded in existing scholarship, but from which actually we can derive a multitude of various rights. I don't have time to talk about why exactly CEDAW and CRPD can be interpreted in a way as to incorporate this test, but what I want to present today is an overview of the framework that I propose, and to show that it's quite broad and flexible, and that actually we can embed a whole variety of different rights that are tailored to the digital context, and we can use this framework. So this test has 6 strands. So the first strand I derived from the work of Martha Feynman, and under this approach, there is a discrimination whenever the use of an artificial intelligence decision-making process results in an inequitable situation. So how do we define inequitable? Well, Martha Feynman argues that inequality becomes constructed when people are embedded in relationships with each other and institutions in a way which results in people having unequal access to resources. And we also have inequality whenever the operation of an institution, for example, places individuals in an unequal situation. So this is the dimension that I add, and actually it's also with the input of Martin Shainin. So based on this first limb of the test, what are the types of rights that we can derive? Well, I argue, first of all, the first right that individuals have is to be able to object to the use of artificial intelligence decision-making processes. And in the context of disability, persons with disabilities don't even have to invoke reasonable accommodation. Why? Well, because we have evidence that the use of artificial intelligence decision-making processes replicates and entrenches inequality. So, for example, Virginia Eubanks is someone who wrote about this issue. And I want to use the example of disability to show how actually the use of artificial intelligence decision-making processes constructs disability. Why is this the case? Well, artificial intelligence, in effect, uses statistical analysis to generate predictions about people. So when it generates decisions, as Lynn Taylor points out, it's not that it uses data about the person, it uses data about people whom it treats as being similar to the subject of the decision-making to make that prediction. And we know from the work of Anja Beckman that because artificial intelligence technology uses statistical techniques, some people are always going to be represented as outliers in the data. And I argue that this issue is especially acute in the context of disability, and actually people are likely to be consistently modeled as outliers. Why? Well, disability is very diverse, right? And someone can be mapped as an outlier because, first of all, the way in which, for example, their body language, for example, can be different from a person with a different disability, or different from someone who doesn't have a disability, and because statistically speaking, people who have a specific type of disability, they are lower in number compared to people with other disabilities or don't have a disability. So inevitably we are going to have a situation where persons with disability are going to be mapped as outliers. And I argue that, well, this is very much a construction of human difference and disability. Secondly, I argue that in terms of placing people in equal relationships, another aspect is that there is a duty to consult persons with disabilities. Now, the duty of consultation is very much part of the human rights framework. Equals Rights Trust has written a paper about the importance of consultation. And I argue that there's a duty under this test for meaningful consultation, meaning that people have to have substantial input into actual decision. So it's not enough just to ask their opinion. They have to have a substantial input into the actual substance of the decision and into the outcome. Now, there are a variety of other rights which we can derive, but I want to move on to the second limb of the test, which is that there is discrimination whenever the employment of artificial intelligence decision-making processes inhibits the ability of people to define and to express their identities. Now, as we know from a lot of equality scholarship, discrimination arises because dominant groups define non-dominant groups in a way that is both inaccurate, distorts people's identities, and also undermines their dignity. So this is really important. Now, this right is very important in the context of artificial intelligence technology because, as Julie McGee points out, companies are suddenly identifying leadership potential with such lifestyle choices as reading a particular newspaper. So I argue that if someone is penalized because, for example, their hobby, they're gardening, or because they're reading historical novels, or because they have political beliefs, or because they dress in a particular way, or because they have a tattoo, so our personal identities are quite complex. So in essence, if the use of artificial intelligence decision-making process penalizes someone because of how they define or express their identities, then this will be encompassed as discrimination. The third limb of the test is, again, based on the work of Martha Feynman. There is discrimination if the use of the artificial intelligence decision-making process impairs someone's ability to access resources which are crucial to their self-realization and which enable them to be resilient in the face of setbacks. Now, in the context of artificial intelligence technology, we can have a situation where if the developers use data to create a model of the world in the system which doesn't represent everyone in the population, then it means that people whose data is not properly represented in the data set will be negatively affected. So this limb of the test will cover these types of design choices. Now, we also know from the work of Angular that in the context of disability, for example, it's impossible to gather data which represents everyone with different types of disabilities, or it's so costly that it's almost financially not feasible. So clearly in some such cases, the use of a particular artificial intelligence decision-making process will be prohibited as such. Now, I would like to move to the next limb of the test. There is discrimination if the operation of the artificial intelligence decision-making process places someone at a disadvantage. So this can happen if the data embeds societal inequalities. And we know from the work of Cathy O'Neill that there are many ways in which data can incorporate existing injustices. So, for example, we know that there is over-policing of the communities of color because the police records are biased, but also because historically police targeted people of color. So, of course, if you target a population, then you're going to have more information and more records about this group of the population. We also have another example, where the word disability is associated with homelessness and drug use, and where actually persons with disabilities were flagged by content moderation systems as a risk. So this is another example of these historical biases and biased practices becoming encoded in the data. So developers use data which already incorporates social injustices and past problematic practices, then there is discrimination. Now, another limb of the test is based on the work of Tarun Kaitan. And Tarun Kaitan, so based on this limb of the test, there is discrimination if the employment of the artificial intelligence decision-making process fails to account for how structural inequality influences people's access to opportunities. So we know from the work of David Oppenheimer that we have a real intersection of inequality in healthcare, education, banking, policing, transportation, etc. So these injustices of unequal access to different resources intersect and really influence people's opportunities. So if the developers in creating these systems don't take into account into how our societal structures interplay together and influence someone's opportunities, then there is discrimination. So for example, the use of the artificial intelligence decision-making process that only uses test scores and ignores people's transferable skills and a diversity of experiences is an example of a situation where the developer in designing the system fails to account about structural inequality. The last limb of the test is based on the work of Deborah Hellman, who, and on this limb of the test, there is discrimination if the use of artificial intelligence decision-making processes either creates a new type of harm or exacerbates a past harm. Now here, what is really important, and I draw on the work of Sandra Wachter, is that the use of artificial intelligence decision-making processes can create entirely new disadvantaged groups which don't make any sense to people. So for example, the examples Sandra Wachter gives are someone can be penalized if they own a dog because of their zodiac sign, because they're a video gamer, or because of the people they have in their social network. And I argue, well, this type of problem, the creation of new groups, can be interpreted as a new type of harm. And also for some individuals, these new groups also exacerbate a pre-existing harm. So for example, if someone is practicing Buddhism and meditates and is penalized because of, for example, streaming videos on YouTube, then clearly this is an example of an exacerbation of existing discrimination against someone who is a religious minority. So I just want to finish by saying that there are all types of different types of decisions of developers which can be incorporated in this test. I don't have the time to cover everything, but the idea with this test is that it actually gives people control over, first of all, decisions what kind of research to fund, design decisions, decisions over use, decisions over sale and purchase of these systems. The idea is that this test would encompass any type of decision that relates to the design of the system and also outcomes. So people can use this test, for example, to challenge the type of inferences that the system makes about the person based on analyzing group data. Now, I'm very happy to announce that this article was very recently accepted to the Human Rights Law Review, so you can read about it. And Martin Shainin, I have been working with him, and he has been showing how this test can be incorporated in other human rights treaties, such as the ICCPR. So we only looked at international treaties. We didn't look at the regional treaties. So thank you very much for your questions.